this installment of Washington Legal Foundation's Legally Brief, we're joined by Claudia Sokanu, a partner with the law firm Arnold & Porter and author of a forthcoming Washington Legal Foundation monograph on the Foreign Corrupt Practices Act. Claudius, the so-called Dodd-Frank Financial Services Regulatory Reform Law created a whistleblower program to be implemented by the Securities and Exchange Commission. Tell us a little bit about how this whistleblower program will apply in the context of the FCPA.
Thank you, Glenn. The new whistleblower provisions on the Dodd-Frank statute provides that any person who provides original information to the SEC about a securities law violation, including for purposes of our question, the FCPA, that leads to an SEC enforcement action where penalties of $1 million or more is imposed, that individual shall be entitled to 10 to 30% of the total penalties imposed by the SEC. That total amount is going to be decided by the SEC, but in no event will it be less than 10% and obviously not more than 30% of the recovery. What that means from an FCPA perspective is if you look back over the last several years, there's been a significant number of cases where hundreds of millions of dollars in penalties had been imposed on companies, both U.S. and non-U.S. companies. And so cases like the Siemens case where $800 million US was imposed on Siemens would have created an $80 million windfall if the information leading to the prosecution of that case had been provided by an employee, wherever in the world that employee might have been. Similarly, with cases like KBR and British Aerospace, you've seen hundreds of millions of penalties. In the BAE case, it was $400 million in penalties. In the KBR case, it was over $500 million in penalties. Any one of those cases would have created tens of millions of dollars in windfall for individual employees. So that's what the statute does, and it creates that incentive for employees, not just in FCPA cases, but in all securities law violations to run to the SEC.
Most FCPA enforcement actions arise from companies who voluntarily disclose violations to the SEC. How will the new whistleblower incentives affect these disclosures? Will there be a race to disclose, and what happens if the company doesn't win that race?
Glenn, that's a very good question, and it's one that a lot of companies are struggling with. The way the statute is currently structured is that an individual employee must provide original information, and that creates an incentive for that employee who comes into information that could lead to a potential violation of the FCPA to raise to the SEC and file a complaint, which actually can be done through the SEC's website. Once that complaint is filed, that individual's self-claim is in essence. And so what companies are struggling with is deciding when they become aware of potentially violative conduct, at what point in the process does a company go to the SEC to self-report? Because as we know, when a company self-report a potential violation and does an internal investigation and cleans up that bad conduct, that company gets a benefit from the SEC and from the Department of Justice, which can be significant. So now companies are left to decide, as soon as they've come in contact with information, whether to run to the SEC or the Justice Department and self-report that as a placeholder so that they can be allowed to get the benefit of the credit of doing an investigation and cleaning up, whilst on the other hand, you've got individual employees who are also running to the government, in this case the SEC, so that they can get the benefit of a 10 to 30% recovery should one come. So it does really truly create a friction between companies and their employees, and I'm not sure what the value of that is, but that's the current regime in which we work.
What, if any, adjustments do affected businesses need to make to their compliance programs to address this whistleblower program?
I think it's early days yet, and we will see how the statute will be implemented. The SEC was given 270 days to come up with rules around the whistleblower provisions, which by my count puts us somewhere in April when those rules will take effect. So companies, when they have comments about the statute, still have the opportunity to influence the SEC's rulemaking. But by and large, what we're really looking at is companies going back and taking a look at their compliance programs taking a look at how they respond to potential FCPA violations within their different organizations, and speaking more to their employees and causing them to want to come forward to the company rather than going over to the government. In some cases, companies have to be seen to do the right thing, but they must be seen to do the right thing quickly and by their employees, thereby creating an incentive for employees to come to the company rather than going to the government. I think the problem, and it's a really significant problem, is that an individual employee who is sitting on information that is worth some amount of money by that individual's calculation is far less likely to go to the company than he or she is to go to the government. So I'm not sure how that's going to play out. We may see we may see the SEC address that problem in its rulemaking, but I think it creates a real incentive for companies to be clear about how they respond to potential FCPA problems, not just with the government, but with their employees.
Claudius, thank you for joining us today.
Thank you.